Quick heads up before we start. This sounds like dry constitutional law, but it's anything but. What you're about to hear could quietly rewrite how probable cause is handled in this courtroom. Stay locked in because the details matter.
When a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
Hey there, welcome to the Courtroom Files. So this interaction from Judge Fleischer's court is something that we caught in part during this morning's live stream that we did, and I promised that I would go back and piece it all together, and I'm glad I did, because this is some of the best lawyering I have seen in all of the hours that we have watched court to make this channel happen. So this defendant is in Judge Fleischer's court for a bond violation. The attorney asked to rehear probable cause, and then she puts together, with the help of another attorney and a little bit of time, an argument that challenges probable cause in the first place. And quite frankly, if anybody was paying attention,
this is where great lawyering separates itself from routine lawyering. The defense isn't just reacting, they're reframing the entire issue. What looks like a simple bond violation is turning into a constitutional challenge with real consequences.
Could very well change how probable cause is approached moving forward in Judge Fleischer's court. So I find this interaction incredibly significant, but I'd like to know what you think in the comments. Please take a look at the whole thing, and at the end, let me know your thoughts. In my mind, this changes things for any attorney that's paying attention, but I'd like to hear what you think. So please do let me know. Put a thumbs up on the video if you enjoy this. Consider subscribing to the channel if you haven't already, and let's go ahead and roll this game film.
Oh, I'm sorry. I didn't even see. Please.
I'm approaching on laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right. This is
You don't think there's PC?
laws. Law. Yes.
You don't think there's PC?
I don't. Looking at the dims, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case, and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But
Of course it has been.
Right.
But there's a new set of eyes, you know. Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. Thanks, sir. Look at it. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. Activation. Okay. Officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes while making a turn on the highway. It's traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and an order to hold quiet, please. Hold beer inside the vehicle.
And here's the pressure point. The sworn DIMS document doesn't explain why the traffic stop happened. That missing justification isn't a typo. It's a Fourth Amendment problem. If the stop isn't lawful, everything that follows is on shaky ground.
The FMSTs were conducted. It was a 6 out of 6 on the HE and a 7 out of 8 on the walking turn and a 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was not in the DIMS.
That seems to be from the offense report.
Sure. I mean, what's
But I thought for PC, we just used the DIMS because that was sworn to and not getting into the.
Show me where it says that. I don't know of any rule that says that PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
Because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into.
Sworn document too.
The offense report's on a sworn document.
Thank you very much. I mean, I guess, Your Honor, my thing is it's a public record that they're using them taking the offense report. And also, I have never seen a rule where we have to rely solely on the definition for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look because I don't know. You know.
Okay. I'll
And I'll
go check with
sure.
Ms. Rogers.
Hey, Anna, come on. So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not.
And I'm looking to.
Okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay.
PC, but we're getting that all together.
Me too.
Okay.
For the 26th.
You said pursuant to the consent decree. Is that what you said?
There's a class action lawsuit. It's Logan and Elgin versus Harris County and.
Okay, hold on.
Southern District of Texas. Okay, go ahead and sign, please.
What? Okay, what is it?
Corey Millen? Yeah.
All right, there you go. You're good to go. You're welcome.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Board. And out of that lawsuit, it was just allegations of Fourth Amendment violations because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious. So I'm curious. For PC purposes, can state use an offense report to supplement a DIMS, or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to. The offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the offense report, he is committed a crime. So I mean, I don't say that the offense report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false?
Right, but perjury's
An official document?
a different crime. Because
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant, and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone pointing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
was there blood in this case? Okay, give me 5 minutes.
Okay.
Okay.
If it's okay with you, I'll both.
Can you show them?
Yeah, that's fine.
Anna,
I'm working with Mr. Gladstone.
Anna,
Oh.
you ready?
Yes, Judge.
Mr. Laws, come up.
The student has down to the first board of elections, and we handle this room, to be here today. So, please put down your tree, you can help with it.
That ruling is bigger than it sounds. No probable cause. Not because the facts couldn't exist, but because they weren't presented in a constitutionally proper way. The real question now is, will other defense attorneys start using this exact strategy going forward?
We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand? Yes. You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are,
Sorry.
it's okay. And I think you're right. We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
So, not saying this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because you might get like 15 supplements.
And here's my question then for the board, and with it, I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, let's say we can't take it to grand jury?
You can, of course you can.
So,
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just saying this is for my own.
And you're not going to hurt my feelings if you go to a grand jury.
I know you did.
Oh, really?
I just, so we wouldn't be held to that same standard.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is,
Which is required to
which is good.
Thank you.
God love.